I want you to imagine, just for a second, imagine sitting in a really high-stakes courtroom.
Okay, setting the scene.
Yeah, so you're there, and the lawyers representing the opposing side, they stand up to make their final arguments.
Right.
And they confidently cite 6 perfectly applicable, just utterly devastating legal precedents.
A total nightmare scenario for your side.
Exactly. The judge is nodding, taking notes. Your own lawyers basically concede the point. The whole machinery of justice turns exactly as designed. But there's just one problem, and it's only discovered much later. None of those judgments actually exist.
Wow.
Yeah. They're complete computer-generated fictions. And the crazy thing is, this isn't some, hypothetical scenario we're drumming up for a law school ethics class.
No, not at all. I mean, it is a reality that struck the very highest levels of the judicial system just last month in July 2026.
Yeah.
The Supreme Court of India actually confronted this precise structural failure. It was in a landmark case called Pooja Ramesh Singh v. Jammu and Kashmir Bank Ltd.
Which brings us to our mission for this deep dive into the source material. We want to answer a pretty profound question. When artificial intelligence appears to write the law, can courts actually trust it?
Right.
We're going to explore what this means for lawyers, for judges, and honestly, for the very concept of truth in the digital age. Okay, let's unpack this.
So, to really understand the gravity of what the Supreme Court discovered, we have to look at the mechanics of the dispute first.
Right, the background.
Yeah, and at its core, it was an insolvency matter. It involved a company called Essel Infra Projects and a corporate guarantee connected to loans from Jammu and Kashmir Bank.
But the financial stuff is kind of just the backdrop, right?
Exactly. The financial dispute is merely the backdrop here. The truly historic nature of this case lies entirely in how the legal arguments were manufactured.
Because the initial tribunal handling the dispute, that's the NCLT, India's National Company Law Tribunal, they actually relied on those 6 judicial citations we just mentioned.
They did.
And when you look at the records, I mean, these citations, they looked absolutely flawless.
Perfect formatting.
Right. But when they were finally scrutinized by the Supreme Court, they turned out to be absolute phantoms.
Just made out of thin air.
Completely. Some of the case names were just fabricated outright. Others had incorrect citations pointing to basically blank pages in legal registries.
And most disturbingly, some of them referenced real existing cases.
Yes.
But they quoted these long, highly persuasive paragraphs that the human judges in those cases never actually wrote.
Never wrote a single word of it.
Right. And the term for this, of course, is an AI hallucination. But what makes this specific instance so alarming is that the hallucination successfully bypassed multiple layers of human verification.
That's the scary part.
Right. Because the initial tribunal, the NCLT, they accepted them as binding precedent.
Yeah.
Then the case was appealed to the NCLAT, the appellate tribunal, and those judges, they failed to catch the fabrications as well.
They just waved it right through.
They upheld the decision based entirely on this phantom foundation. I mean, it wasn't until the matter reached the Supreme Court of India and the justices there independently attempted to, actually pull the original text of the authorities.
Because they couldn't find them.
Exactly. That's when a massive structural fraud was exposed.
It's basically the equivalent of building a skyscraper on a hologram of a foundation.
Oh, that's a great way to put it.
Right, because if a lawyer simply misunderstands a real documented case, or maybe they twist a genuine ruling to fit their narrative, you at least have a physical foundation to debate.
You have the book.
Exactly. Opposing counsel can just open up the actual law book, point to the page, and argue over the real words the judge used. But with these AI hallucinations, you're trying to cross-examine a ghost.
A ghost, yeah.
There's no original reasoning to examine because the reasoning never existed in the first place.
And what's fascinating here is the Supreme Court's extraordinary reaction to discovering this hologram.
They didn't hold back.
Not at all. I mean, they did not just issue a mild procedural correction or a slap on the wrist. They completely set aside the decisions that had relied on the fabricated material, but they went a significant step further. The court declared a zero-tolerance approach toward producing, citing, or relying upon unverified AI-generated precedents.
Zero tolerance.
They explicitly stated that relying on hallucinated material fundamentally undermines the sanctity of adjudication itself.
And I mean, quarantining the entire process makes total sense, but I think we have to look at the underlying mechanics here.
Sure.
Because lawyers and judges have been using digital legal databases for decades without this happening.
Right. Westlaw, LexisNexis, all of those.
Yeah. So we need to drill down into why this specific technology, generative AI, failed in such a uniquely dangerous way.
Well, it really comes down to a fundamental difference in architecture.
Okay.
See, a traditional legal database is retrieval-oriented. You type in a query, and the software searches an existing static library of verified documents looking for a match.
Like a Google search, basically.
Pretty much. It either retrieves the document or it tells you, hey, there are 0 results.
Yeah.
But generative AI is built on an entirely different premise.
Right.
Large language models, or LLMs, they don't have a static library of documents that they pull from. They're trained on vast oceans of text, and they learn the statistical patterns of human language.
And here's where it gets really interesting. Because an LLM is, at its core, just a mathematical prediction engine.
Exactly.
It isn't actually thinking about the law.
No.
It's just calculating the probability of what the next word or, token should be in a sequence. I always think it's like having a confidently wrong friend.
So yeah, everyone has one of those.
Right. Say you ask this friend for a sushi recommendation in a new city. Because they can't bear to admit they don't know the neighborhood, they just confidently send you to a restaurant with a highly plausible name.
Right, like Sakura Sushi Palace or something.
Exactly. And when you arrive at the address, you find an abandoned pet store.
Because the friend didn't search a directory.
Yo.
They simply generated a string of words that sounded like a restaurant recommendation based on their past conversations.
Exactly.
And when an LLM generates a legal citation, it's doing the exact same mathematical blending. It maps word relationships. So because the syllables of real judges' names often appear near words like VBank Ltd. In its training data, the AI just clusters them together.
Wow.
And that is exactly why it invents case law.
But the stakes are so different. I mean, if that friend ruins your Friday night with a fake sushi spot, you're just hungry and annoyed.
Right.
But when this exact same prediction mechanism is applied to a Supreme Court precedent, and that fake precedent is used to decide who goes bankrupt or who loses their property or who loses their liberty, you are actively corrupting the integrity of the justice system. And the AI doesn't know it's lying. It's literally just fulfilling a math equation.
And the phrasing used in the source material to describe this phenomenon is so crucial. They call it plausible nonsense.
Plausible nonsense. I love that term.
It's perfect. Because generative AI rarely spits out, garbled, unreadable text when it hallucinates in a professional context.
Right. It looks professional.
It nails the formatting. It gets the judicial tone absolutely perfect. It uses the correct statutory jargon, and it perfectly mimics the structural syntax of a standard legal citation. It basically creates something that wears the uniform of reality.
And our cognitive biases are completely hijacked by that uniform.
Exactly.
Because it looks official, the human brain automatically glosses over the verification step. We just assume it's real because we're so conditioned to trust documents formatted in that specific authoritative way.
We see the formatting and our brain says, okay, this is legit.
Yeah. And because the machine produces this plausible nonsense so effortlessly, the burden of truth inevitably shifts away from the software and lands squarely on the shoulders of the human operating the machine.
And this shift fundamentally alters the workflow of the legal profession. I mean, think that. For generations, the traditional method of legal research operated on a simple 4-step process.
Right.
Search, read, analyze, cite.
Simple.
You locate the case law, you read the judge's reasoning, you figure out how it applies to your client, and you include it in your brief. But the sources make it clear that in an AI-assisted reality, that legacy workflow is completely obsolete.
Yeah, the new workflow expands significantly. It has to become prompt, generate, verify, read, analyze, cite. That extra step, verify, has overnight become the most critical, non-negotiable part of a lawyer's job. Otherwise, clients are essentially paying premium billable hours for a machine to write legal fan fiction.
Right. And verification in this context, it's laborious.
It's not a quick skim.
No, it does not mean simply glancing at the AI's output to see if the logic flows. True verification means taking the citation provided by the AI, completely exiting the generative platform, and opening a traditional retrieval-based database.
Or a physical law report.
Exactly.
Yeah.
Locating the actual judgment, reading the specific paragraph in its original context, and confirming that the ruling hasn't been overturned by a higher court.
Okay, but let me play devil's advocate here, because we know the legal profession is notorious for crushing deadlines and massive workloads.
Sure.
Let's say I'm an overworked junior lawyer. I use an AI tool to draft a massive submission at 2 a.m, and a hallucinated case slips through.
It happens.
But on page 1 of my filing, I put a prominent footnote, and it says, portions of this document were drafted with the assistance of generative AI.
Ah, the disclaimer.
Yeah. Haven't I done my job? I warned the judge. Doesn't that disclosure shield me from professional liability?
Well, the Supreme Court's stance on this is unequivocal. Disclosure does not equal verification.
Okay.
An AI-generated paragraph containing fictitious law doesn't magically become legally valid or ethically acceptable simply because you admit an algorithm wrote it.
That makes sense.
When a lawyer submits a pleading to the court, they physically or digitally sign their name to it.
Right.
That signature is a binding representation to the court that the authorities cited are genuine.
Right.
The lawyer owes their primary duty to the court, not to their efficiency software.
So you cannot outsource your professional liability to an algorithm.
No.
You own the output, regardless of who or what typed the first draft.
Exactly. And the Supreme Court took this evasion of responsibility so seriously in the Pooja Ramesh Singh case that they went beyond just reprimanding the specific lawyers involved.
Oh, they took action.
They formally directed the Bar Council of India to establish a special committee.
Mm-hmm.
The mandate of this committee is to deliberate on the disciplinary consequences for advocates who submit hallucinated material and to draft strict guiding principles for the profession.
Wow.
They're institutionalizing the consequences, turning what might be seen as just a technological faux pas into a codified breach of professional ethics.
Wait, if lawyers are tempted to use AI because they're drowning in paperwork and legal research, I mean, judges have the exact same problem on an even larger scale.
Oh, absolutely.
The judicial systems globally, and particularly in India, they face massive, crippling docket backlogs. We're talking millions of cases pending for years, sometimes decades.
This huge crisis.
So if AI becomes so mathematically sophisticated that it can just ingest every statute, read every past judgment, analyze the evidence, and predict outcomes with near-perfect accuracy in a matter of seconds, what is stopping a judge from quietly using ChatGPT to write their rulings?
It's a fair question.
Wouldn't clearing that backlog be a greater service to society than waiting a decade for a human to process the paperwork?
This raises an important question, and it is perhaps the greatest temptation modern legal systems will ever face.
Yeah.
However, we have to look at the constitutional dimension. Judging is not merely data processing or administrative information sorting.
Right.
Judging is the exercise of public power. When a judge makes a ruling, it profoundly impacts constitutional rights. Society only allows judges to wield this immense power because of a deeply embedded system of accountability and institutional legitimacy.
So if we surrender the bench to an algorithm just to save time, we entirely sever that chain of accountability. If a human judge makes a ruling you disagree with, you can appeal. You can ask them to explain why they preferred one interpretation of a statute over another.
Mm-hmm.
You can interrogate their reasoning. But an AI's reasoning is fundamentally a black box.
Yes. You cannot cross-examine a neural network.
Right.
We do not know the specific weighting of the data used to train the algorithm. If the training data contains historical biases, which, let's be honest, all human-generated data inherently does,
Of course.
the AI will seamlessly replicate and amplify those biases. But it will do so under the sterile, unassailable guise of mathematical objectivity.
And that sterile objectivity is exactly why the Supreme Court insisted on a foundational concept we really have to highlight here, which is the human-in-the-loop principle.
Very important.
Every single stage of the judicial process, a human being must retain active control. AI can be used to assist the machinery of justice. It can summarize 1,000-page documents. It can organize discovery files, spot patterns.
It's great at that.
But the ultimate responsibility, the actual ownership of the decision, it must remain human.
Because a machine does not understand the weight or the real-world consequence of its own output.
No.
It does not possess a working concept of proportionality or constitutional values or human suffering.
Right.
It only understands token probability. The AI can process the data, but only the human can exercise judgment.
And, the human in the loop principle protects how we interpret the law. But zooming out, generative AI is not just threatening the legal precedents we cite, it's simultaneously threatening the raw facts we bring into the courtroom to be judged.
Absolutely.
The ruling hints at an impending massive crisis of digital evidence.
If we connect this to the bigger picture, the crisis of digital evidence is already arriving. I mean, for decades, courts have slowly adapted to electronic evidence, right?
So there are emails, text messages, digital photographs.
Yeah, but generative AI creates an entirely new, infinitely scalable category of threat. We're bracing for a wave of fabricated evidence.
It's terrifying.
Think about deepfake photographs that are pixel for pixel, indistinguishable from reality. Synthetically generated video depicting events that never occurred. Cloned voices that sound identical to a defendant making a confession.
Oh, man.
And completely digitally manufactured financial documents.
Just think about the practical reality of that. Someone could clone your voice using 3 seconds of audio pulled from your public social media.
It's that easy now.
And they use that clone to leave a fake voicemail admitting to a crime. How does a judge or a jury know what to believe?
They don't.
Because the legacy standard for evidence in a courtroom used to rely so heavily on human perception. Does this video look genuine? Does this recording sound like the defendant?
And that sensory standard is now completely obsolete.
Right.
In a world saturated with generative AI, asking if something looks genuine is a useless metric because the entire engineered purpose of the technology is to perfectly mimic genuine reality.
You fool us.
Exactly. The legal system is being forced to pivot sharply away from surface appearance, focusing instead entirely on provenance and metadata.
Let's break down exactly what provenance means in this context for someone listening. It's basically the origin story of the file, right?
Precisely. The origin story. The lawyer of the future will spend less time arguing about what a video shows and significantly more time proving that the video file actually originated from the specific security camera it claims to be from.
Okay.
This involves deep digital forensics. They'll rely on things like cryptographic hashing, which assigns a unique digital fingerprint to a file at the exact moment of its creation.
Meaning if a deepfake generator alters even a single pixel of that video file later on, the mathematical hash breaks.
It breaks.
Instantly proving the file was tampered with.
Exactly that. Courts will increasingly require audit trails and secure digital ledgers to establish an unbroken, authentic chain of events. Mm-hmm. Who created the file? On what physical device? How was it stored on the server? Has it been modified in any way since its creation? If that technical provenance cannot be proven, the evidence simply will not be admitted, regardless of how convincing it looks to the naked eye.
Because appearance is no longer enough. Just because a video looks real or a Supreme Court citation looks perfectly formatted, it means absolutely nothing.
Nothing at all.
The surface is just easily, cheaply faked, no? The truth has to be proven at the structural mathematical level.
Which brings us back to the core lesson embedded in the Pooja Ramesh Singh case.
Yeah.
The Supreme Court of India is not acting like a group of Luddites trying to banish computers from the courtroom.
No, they're not saying ban AI.
Right. They explicitly recognize that the courtroom of the future will absolutely contain artificial intelligence. It's going to be seamlessly embedded in legal research platforms, in court administration software, and in document management systems. Its presence is inescapable and, honestly, if used correctly, highly beneficial.
But it must be fiercely contained as an assistant, never elevated to an authority.
Right.
Because at the end of the day, the entire justice system, the whole reason society resolves disputes in a courtroom rather than out in the streets, it relies entirely on one abstract concept, which is trust.
Trust that the law being cited by the lawyers actually exists in the real world.
Mm-hmm.
Trust that the evidence presented to the jury is genuine. Trust that the reasoning behind a judge's ruling can be examined, debated, and appealed.
Right.
And ultimately trust that a human being is accountable for the severe consequences of the decision. Artificial intelligence is a miraculous tool for manufacturing text, images, and legal arguments at scale, but it cannot manufacture trust.
So what does this all mean for you listening to this today? I mean, it means that the paradigm of knowledge has fundamentally shifted.
Complete.
Whether you're a lawyer drafting a brief, an executive prepping for a critical boardroom meeting, or just a citizen reading the news on your phone, your primary objective has changed. The most important skill you can possess is no longer knowing how to find the answer.
An AI assistant will find an answer for you in 2 seconds.
Right. The most critical, indispensable skill of the modern era is knowing how to verify if the answer the machine just gave you is actually true.
It's a massive societal shift from search to verification, and it requires a completely new, incredibly rigorous kind of digital vigilance.
Yeah. I want to leave you with a lingering thought to mull over, building on what we just discussed about the necessity of keeping the human judge in control.
Okay.
We talked about the dangers of an AI hallucinating fake precedents. But consider this scenario. What if a human judge starts using an AI assistant to help draft their legal reasoning, and that specific AI model has been heavily trained on that judge's own past rulings to perfectly capture their voice and style?
Oh, wow.
Right. Is that judge actually making an impartial, objective decision on a new, unique case? Or has the AI simply created a perfect digital echo chamber, seamlessly feeding the judge's own pre-existing biases and past habits back to them, cleverly disguised as objective, machine-driven analysis?
It is a profound philosophical question about whether our technology will ultimately expand our judicial perspective or simply perfectly replicate our human blind spots.
Imagine sitting in that same courtroom we talked about at the beginning. The citations are real this time. The precedents exist. But the reasoning that ties them all together, the logic that decides your fate, was quietly curated by an algorithm designed only to tell the judge exactly what they already wanted to hear.
That's chilling.
Who is really writing the law then? We'll let you ponder that one on your own. Until next time.
Subscribe to Ambat Legal Insight and stay legally informed with clear, practical, and reliable breakdowns of the law. Follow our channel and activate the bell icon so you never miss important legal updates, case analyses, and expert insights that matter to every citizen. Support our mission of spreading legal awareness by liking, sharing, and commenting, because your one action can help thousands become more legally empowered. Join the ALI community today across YouTube, podcast, and social platforms and take a step toward understanding your rights, your laws, and your justice. Ambat Legal Insight, because law is for everyone.